Chairman.
Phil Goff.
Mr Chairman, thank you very much. This part of the bill deals, in fact it's entitled Detention and Supervision of Persons Posing Very High Risk of Imminent, Serious, Sexual and Violent Offending. Each of the words in that title are really important to the issue that we have under discussion. It is about people at very high risk. It's about people who, if released, will imminently undertake an offence, and it's about people who already have a track record of serious sexual or violent offending. I want to refer to the definition of the word imminent because I think it's particularly important to what some people see as the rather extreme nature of the power that's being exercised here. Imminent means, in relation to the commission of a serious sexual or violent offence by a person, that the person is expected to commit an offence as soon as he or she has the opportunity to do so. That's what the word imminent means. As Minister of Justice, I dealt with cases like this. I had reports from psychologists and I had reports from people who worked within the system that if person A was to be released, on the way out of the prison, if an opportunity arose, that person was so driven that they would commit an offence. So we're not talking about the use of extreme powers in the cases of people where there might be a whole lot of alternatives in terms of how to deal with them. Mr Speaker, it is about human rights, and I respect the viewpoint stated by the Greens about the right of a person that is given a determinate sentence normally to be released at the conclusion of that sentence. That is the norm, that is what we would expect. But if a person is regarded as being of imminent risk of seriously offending against another innocent individual, then surely in this House we have to consider the human rights of those who are almost certainly going to be the victims of the individual released. We are not talking about using this powerful legislation against scores or hundreds of people. What the Select Committee was advised was that over a 10-year period, maybe there would be 5 to 12 people who would be encompassed by it. Maybe one a year, maybe one every 2 years. We are talking about extreme cases where the balance moves from the right of the person who has already committed a serious violent or sexual offence to be released at the end of their sentence if they are certain to offend again, and that is the clinical judgment and the independent judicial judgment made about that individual. Then in my mind the balance switches to protecting the likely victim of that individual. Freedom is a really important right, but it's not an absolute right. It's not an absolute right, as we know, because if you commit a criminal offence, you are jailed. For some people who meet the category covered by this bill, it would have been better that they were sentenced to preventive detention. Preventive detention is an indeterminate sentence that says you will be locked up and kept locked up for as long as the safety of the community justifies that. Maybe it would be better if the judge had had the foresight, and the judge can't always have the foresight, to see that this person is of imminent risk of offending. Sometimes, after a person has been in prison for a long period of time, they have changed. They are suitable to be rehabilitated and to be released. But sometimes at the end of the sentence, the psychologists say this person has not changed at all. This person is going to do exactly what they were imprisoned in the first place for doing as soon as he gets the opportunity to do so. Now, I said before that freedom isn't an absolute right. We detain people under the Intellectual Disability Compulsory Care and Rehabilitation Act. If people do not have the intellectual capacity to be responsible for their actions and they're likely to harm themselves or others, we detain them. And nobody screams about human rights as long as the law operates under close supervision and under tight, Mr Chairman, under tight constraints.
The Honourable Phil Goff.
We detain people under the Mental Health Compulsory Assessment and Treatment Act. Nobody says that it is an appalling breach of human rights that a mentally disordered person is detained under that act. They are detained for their safety and for the safety of others. And the argument that I would make in relation to my colleagues from the Green Party is that these cases aren't actually, in essence, very much different from what I've just talked about. We dealt with the problem of people who had personality disorders. They are not under the definition of the Mental Health Act, but they are that category of people that Jenny Shipley's legislation released in the 1990s, and psychiatric nurse Neil Pugmire said, "This will be a disaster for New Zealand." He was hounded out of his job, but he was absolutely right, because these were people that were driven, that suffered both compulsive behaviour, inability to identify with their victims, and would go out and offend again. That is exactly the case that Neil Pugmire was in. He will be dealt with under the companion piece of legislation here, the Parole Extended Supervision Orders Act, but he could be dealt with under this legislation. So I say, Mr Chairman, that though this legislation goes an incredible distance in saying when a person has finished their sentence, they can still be detained in a secure facility, there is good reason for that, as long as the law is clearly defining the persons concerned, a judge is making an independent and informed judgment about it, and the judge is relying on the professional advice of people that have had years and years to consider the nature of the individuals concerned. Mr Speaker, the four principles set out in the bill, I think, are incredibly important. That the public safety, the public protection order is not imposed as a punishment. If this was designed to be a punishment, we would be in breach of international human rights. This, by the way, did not, according to the Attorney General's Office, breach the New Zealand Bill of Rights Act, because it's a civil regime. It says that it should only be imposed if the magnitude of the risk justifies it. I've outlined some of the circumstances how you might define that. It says it should not be imposed if the offender is eligible to be held under the mental health or intellectual disability legislation. I've equally covered that. And it says that people thus detained should have as much autonomy as possible. And the interesting thing, Mr Chairman, is that under Part 1 of this bill, there is a whole section of the bill that sets out the rights of these individuals. You know, they are allowed to do things that normally people imprisoned would not be able to do in equivalent circumstances. They can earn money from their work, they've got the right to vote, they've got the right to recreational and cultural activities, to receive and send written communications, access to the media, and so on. I think what those rights demonstrate is that this regime is not a regime designed to punish. This is not a regime that is unfair. This is a regime that is premised on the need to protect the rest of society and its most vulnerable members from the activities of these individuals if released. So I find, Mr Chairman, that I cannot agree with my Green colleagues' minority view that this is disproportionate and excessive in relation to the level of threat to public safety that actually exists. I have been in the situation as a minister in dealing with these cases, and I regret to say that there is a real risk of safety. I have seen the consequences of what people have done because they cannot in any way have empathy with their victims. They do not understand the quality of their actions. Mr Speaker, it is a form of detention, but it is not an imprisonment designed as a punishment. The interesting thing about this bill, and maybe I'll make this as my last point, is that this bill, despite the fact that it keeps people in secure detention, is not in breach of the New Zealand Bill of Rights. And the next bill that we will examine as a House, the Parole Extended Supervision Orders Bill, actually allows people to be out in the community and monitored, but is in breach of the Bill of Rights. And I think, you know, there's a discrepancy there. The form of detention that is less dramatic is in breach, and the one that is more dramatic is not in breach. But Labor supports this bill and this part.
Barbara, courage.